Welcome and thank you for attending. All parties are in listen-only mode for the duration of the presentation. A copy of the presentation will be sent to all attendees following today's webinar. Questions may be asked the presenter via the questions pane in the webinar control panel. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to your presenter. You may begin.
Good afternoon, Long Island employers. My name is Brendan Sweeney. I'm an attorney in the Long Island office of Jackson Lewis. And hopefully you can see from the presentation that we were thinking about the long weekend, just like I'm sure you are. But this week, a very important decision came down from the United States Supreme Court, and that is the topic of our webinar today. I've been practicing employment law for a little more than 20 years. I spent about half of that time as an in-house lawyer for a company called Luxottica that makes and sells eyewear. And in 2007, Luxottica was facing two significant wage and hour class actions in California. And after a significant amount of analysis of many of the same issues that we will talk about today, we at Luxottica decided to implement an arbitration agreement and a class action waiver. And I led the implementation and the defense of that agreement. And on several occasions, I had the great experience of telling our business leaders that a class action that had been filed against the company was now a single plaintiff case in arbitration. So the arbitration agreement and class action waiver for that company at that time was a very, very big success. That does not mean that arbitration agreements with class action waivers are right for every company, and we will talk about some of the considerations that should go into that decision today. There's no doubt that this is a very positive and very significant development, but it's not a simple decision to put an arbitration agreement and class action waiver in place. And this webinar will not be about the legal nuances or the policies behind the Epic Systems decision. This webinar is intended to be a practical overview of the realities of what you deal with and what you may be asked to consider after this decision. So, first, a little bit of background. Epic Systems is the name of the big case that just was decided. It was actually three cases. There was a case against Murphy Oil that was handled by Jackson Lewis, and a case against Ernst & Young, and those cases were consolidated. Before the decision, more than 50% of private employers were already using arbitration agreements, and more than 30% were already using class action waivers. So why is Epic Systems such a big deal, and why is it getting so much attention? Epic Systems is important because it gives employers certainty. The court held that an employer can require employees to agree to resolve disputes in arbitration and can include in that agreement a class action waiver. The court rejected arguments that that type of agreement violates workers' rights to act collectively. So the decision provides a great deal of clarity. In many places, arbitration agreements were already enforceable, but several circuit courts had held they were not. And Epic Systems is important because of this certainty. We probably all know that employment litigation has been booming for many years. And continues to boom. If you deal with employment litigation, you know that the worst thing you can get is a class action. Class actions are very expensive to defend and very expensive to settle. So just a little bit of numbers shows that if you can avoid a class action, you have to give that serious consideration. In addition, employers deal with juries, and juries in employment litigation are dangerous, and we often try to avoid them because they are unpredictable, and there is no question that there is a real thing called a runaway jury. Juries can sometimes grant awards that are out of any proportion to the reality of the case. So a class action waiver and arbitration agreement is important both because it can help you avoid class actions and it can help you avoid juries. So should we implement a class action waiver and arbitration agreement? One way to look at this is to look at the advantages and disadvantages of arbitration. And we'll talk about whether you can have a class action waiver without an arbitration agreement, but most of the law on this looks at these things as a package, and most employers are including class action waivers in their arbitration agreements. Arbitration has definite advantages. It helps you avoid runaway juries. It provides greater privacy, not absolute confidentiality, but certainly significantly greater privacy than in court. It typically means the case will be resolved in a shorter amount of time, and you can do certain things in your arbitration agreement. And one example is tailoring the discovery rules so that discovery is more limited. There are also disadvantages. In individual cases, arbitration tends to be more expensive for employers. Now, that's just comparing an individual case in court versus an individual case in arbitration. The overall savings from avoiding class actions is another part of the analysis, and we'll get to that. But if you just compare individual cases, arbitration tends to be more expensive. Also, there is a risk, and it's a growing risk, that plaintiffs' lawyers will file a large number of individual cases in arbitration to get around the fact that they may not be able to file a class action. This is a relatively new tactic of plaintiffs' lawyers. We're seeing it, and it is clearly to gain leverage and to inflict cost on employers. So that's a consideration as well. It's also very difficult to obtain summary judgment in arbitration. It's not to say it's impossible, but it's very difficult. Most arbitration cases actually go to a hearing, and that is different from court, where very few cases end up in a trial. You also have to accept the reality that arbitrators tend to split the difference or split the baby. That is a fact, and arbitrators have to be hired by both sides, so they're very careful to have reputations to be fair to both sides. And sometimes it means they give each side something. And finally, there's almost no right to appeal. So there are clearly advantages and disadvantages of arbitration. In my opinion, if you're asked the question of should our company implement an arbitration agreement and class action waiver, the first thing you should look at is your risk of a class action. Really analyze whether you're a company that is at risk, and certainly Jackson Lewis can help with that. If the risk is high, you certainly want to address the issues, but I would also strongly recommend an arbitration agreement and class action waiver. If the risk is low, the disadvantages of arbitration may not be worth it. And there are many factors that go into your class action risk, not something we'll address in this short webinar, but that is the starting point, in my opinion, for deciding whether to adopt an arbitration agreement and a class action waiver. And the answer does not have to be all or nothing. For example, we are seeing a tremendous amount of litigation from contingent workers, from either independent contractors or people who claim that your company is a joint employer. In my opinion, it's a very good practice to use an arbitration agreement and class action waiver with independent contractors. Make sure that your staffing agencies are including arbitration agreements and class action waivers in agreements with their employees that protect you and protect you if you're claimed to be a joint employer. So again, not an all or nothing proposition. So you decide you want to go down this road, what's next? The basis for enforcing class action waivers is usually an arbitration agreement, and the FAA refers to the Federal Arbitration Act. The significant decisions that have come down have held that there is a strong federal policy in favor of arbitration. And the key is to have a valid arbitration agreement. And usually the simplest way to look at that is to put a fair agreement in front of your employees. You can do it with new employees. You can generally do it with existing employees, although there are some nuances to that. Some states require consideration beyond continued employment. Some do not. If your state, and New York does not necessarily require it, but if you're operating in states that do, the consideration can be something small like additional PTO. It doesn't have to be a significant payment, although you can certainly put it in a bonus plan. You can put it in a stock option plan, and that's what many employers do. The agreement has to be mutual, meaning that both the employer and the employee are giving up their right to go to court and agreeing to settle just about every dispute in arbitration. There are some exceptions, cover them briefly, but mostly you're agreeing to resolve all disputes either way in arbitration. And finally, you'll have to think about how you make sure you can prove that your employee agreed to the arbitration agreement. Some do that with electronic signatures, and it's important to be careful to follow the rules on electronic signatures. Others do it the old-fashioned way, but you need a clear agreement with clear assent. We, again, recommend that the agreement be fair and sometimes a little bit more than fair. Generally, all employers agree to pay the costs of arbitration. The arbitration agreement will require that the arbitrator issue a written award with reasoning. The arbitration agreement usually refers to rules such as AAA rules or adopts another organization's rules for arbitration. You do not reserve a right to amend the agreement, and this is why we don't generally put these in employee handbooks. You usually want to reserve the right to amend your employee handbook. You can make this a supplement to the employee handbook or a standalone agreement, but it has to be clear that it's an agreement that's not going to be amended without a new written agreement that's signed by both parties. Again, it has to be mutual. There should be a severability clause, which allows a court to enforce the arbitration agreement even if other parts of the agreement are not enforceable. And we are certainly recommending taking an approach of having a dispute resolution agreement. Many employers will say that the first step should be a mediation process and step 2 should be an arbitration process. And in my opinion, that's a good way to approach this. It is fair and it looks fair. And finally, we certainly are recommending if you're going down the arbitration route, most employers are going to want the benefit of the class action waiver. Rolling these out is about good employee relations and good communications. There will be a lot of press about how the Supreme Court's decision is unfair and it gives too much power to employers. I personally don't agree with that. I think the Supreme Court's decision is a big negative for plaintiffs' lawyers. It is not necessarily a negative for employees or employers. There is a great deal of research that shows that employees do just as well, if not better, in arbitration than they do in court. What they lose is the leverage of hanging a class action over an employer. So one-on-one arbitration is fair, and employees do fine in one-on-one arbitration. But you need to be careful about these things because unions will certainly be out saying that employers are taking rights away from people and they need protection. So a careful rollout is very important. Okay, a few frequently asked questions. Can we require current employees to agree to an arbitration agreement and class action waiver without an additional consideration or payment? In New York, continued employment is sufficient. In other states, it may not be. So that has to be carefully analyzed. It's a very easy thing to have these agreements with new employees because your consideration is the offer of employment, but for current employees, you have to be careful. Are there certain types of disputes that cannot be forced into arbitration? Yes. Individuals cannot be barred from going to the EEOC. They can't be barred from going to state agencies or making claims for workers' comp or unemployment. A number of states, including New York, have passed laws that say that certain types of claims, and today it's sexual harassment claims, cannot be forced into mandatory arbitration. If you make your class action waiver part of an arbitration agreement that complies with the Federal Arbitration Act, New York's law is probably going to be found to be irrelevant and preempted, and the arbitration agreement is the reason for that. So that is another reason we are not recommending, and I'll skip to the next question, but many employers look at arbitration and say, well, can we just go to court but have a class action waiver? And the reality is that is unclear. It is possible, and some courts have enforced those types of agreements. Others have rejected them. But if you go that route, you lose the benefit of the Federal Arbitration Act preempting state laws. So if you have that kind of agreement, you may have a state law problem. So obviously something to carefully consider. Can an enforcement agency like the DOL or the EEOC bring a claim on behalf of multiple employees? Yes. A private arbitration agreement does not trump those enforcement powers. Can an individual stand in the shoes of an enforcement agency and bring a representative claim on behalf of other employees? Well, that's permitted in California today. California passed something called a Private Attorney General Act. It allows people to bring claims on behalf of their coworkers. It only goes back 1 year and has some other things that are better than a class action, but it looks an awful lot like a class action. I do think eventually the U.S. Supreme Court will say this is not allowed, but today it is allowed, and there is an active effort in New York to pass a New York Private Attorney General Act. So stay tuned on that. And finally, should we expect that the lawyers who represent employees will just close up shop and go away? No. There are many lawyers who have made a career of representing individuals, and they will continue to do that. They will look for grounds to invalidate your arbitration agreement. If that doesn't work, they will look to, as I said, band together. They'll be on Facebook and on other social media platforms rounding up plaintiffs and making it expensive for employers to pay all the arbitration fees and deal with a large number of individual cases. Some firms will be able to do this, some won't, but it is a tactic that is being talked about. As I said, unions will use this as an organizing tool, and they'll work with the plaintiffs' lawyers. The plaintiffs' lawyers may find creative ways to finance these gathering of plaintiffs and suing in lots of individual cases, and they'll lobby for more laws like California's PAGA. So this is not an answer to every employment litigation risk. That said, on balance, as I said, in my experience, arbitration agreements with class action waivers are very beneficial to many employers, and avoiding a class action is incredibly good for protecting your companies from expense and risk. And as we said at the start, there's a lot of cases being filed and a lot of lawyers out looking for ways to make employment litigation expensive. So any employer who has to deal with that reality has to give this serious consideration. So if we can help you assess your class action risk, please contact us. If we can help you talk through this important decision, please contact us. And we are hearing from many, many clients who want to at least consider going down this road. And for many of them, it's a great idea. But hopefully I'm leaving you with the understanding that it's a question that should be carefully considered, potentially very, very big positive for employers, but one that has to be done in a careful way. So with that, I hope everybody has a great long weekend and that you will avoid litigation. Thanks, everyone.